It was a ticking time bomb. Really, the next person to touch it, if they made any contact at all, it was coming down.
A catastrophic injury, an alleged corporate cover-up, and the largest bodily injury verdict in Connecticut history. Welcome to Make Your Case, the podcast where attorneys break down the most impactful cases of their careers and the stories behind them. I'm Joe Douglas, longtime investigative journalist and founder of Clear Eyed Media, where we produce legal videos that help lawyers win cases and reach better outcomes. Today's guests are Andrew Garza, Alexa Mahony, and Andrew Ranks, partners and trial attorneys at Claggett, Sykes Garza in Connecticut. Together, they secured a $100 million jury verdict for Juan, Mikey, Cruz, and his wife, Emily. That after a 1,300-pound pallet of fluorescent light tubes in a warehouse fell and crushed Mikey's spine. Now, in this episode, they reveal how they uncovered evidence the defense insisted didn't exist, why a key piece of damaging drug evidence was ultimately kept from the jury, and why that may have helped their case, plus how their relentless Woodpecker approach helped crack corporate defenses wide open. Thanks to all three of you for being here. To start, please go ahead and introduce yourselves.
So my name is Andrew Garza. I'm the co-owner and co-founder of Claggett, Sykes Garza here in Connecticut. It's a firm we opened about a year and a half ago with some partners, Sean Claggett, Matt Granda, and Will Sykes out in Nevada. And happy to be here. Thanks for having us, Joe.
Good morning. My name is Alexa Mahony, and I'm a partner and trial attorney at Claggett, Sykes Garza here in Connecticut.
My name is Andrew Ranks. I'm also a partner and trial attorney here with Claggett, Sykes Garza. I joined the team shortly before the Cruz trial that I think we're going to talk about today, as did Alexa, and we've been a team together ever since then.
Great. And so are you guys based in, where are you based in Connecticut, just on camera?
Just a touch west of Hartford. So Hartford's the capital city in the center of Connecticut, but we take cases statewide and do consulting and co-counsel work across the country, but headquartered in Connecticut.
Cool.
In Farmington.
Great. And so I do cases that are typically like big cases in a lawyer's career or in a firm's career. And so what makes this like a notable case, and how did you guys get it? How did you first get what was the intake?
Yeah, so initially the case came in actually as a workers' compensation case, which they sometimes do. You know, folks get hurt at work and they think sort of that's the only remedy they have. But every one of those cases that we look at, we look to see, is there something more here? Because comp has its benefits, but they're limited and there are compromises in that system. So when this case came in, and certainly once we realized that our client was paralyzed, which we knew, immediately, we decided, we have to look at absolutely every possible avenue of recovery, leave no stone unturned, and figure out, exactly who touched this product and how the events happened that day.
And you guys, Andrew, Alexa, when you first got brought into this case, what was that experience like for you? What did you first see or notice right off the top?
Sure. So I joined the firm. Well, I joined working with Andrew Garza in January of 2022. So the actual incident had happened years earlier, and Andrew had already done a significant amount of work at that point. One thing that I noticed immediately was that his wife, Mikey Cruz's wife, Emily, who was also a plaintiff, had a loss of consortium claim that hadn't really gotten a lot of attention. So one of the things that I was excited to sort of jump into when I joined the team was working with Emily and kind of building up her case.
What does loss of consortium case mean?
Yeah, so in Connecticut, it's a cause of action where a spouse of an injured plaintiff can bring a claim for the impact that the injury and the losses the injured spouse suffered, the impact that it's taken on their marriage, their relationship, things like that.
Okay.
Yeah, we typically think about it in the most kind of basic ways, like the physical aspects of the relationship, intimacy, which obviously would be affected in a case like this. But as part of the work that Alexa did was building up that it's a lot more than that. It's about the all aspects of the relationship and how that routine that we have as a couple gets broken down when something catastrophic like this happens. And thankfully, the law recognizes that as a loss, and so Alexa was kind of instrumental in building that up.
Cool. And I think we will probably come back to that. But we want to kind of start out with how we perceived this early on. And Andrew, what was when you first got into this case, what was your perception early on? Or
Yeah,
what did you do?
so when around the same time as Alexa, Attorney Garza, Andrew reached out to me, and I was working as a defense attorney, and asked if I could help out on a case that was coming up for trial later in the year. So when I came in, Andrew had done a ton of work, a ton of great work building the case up. And really what we were at a position of at that point was trying to take all of the work that Andrew had done and really get it ready for trial to kind of tell that story of the client, what happened, and make it digestible for a jury at the end of the day. So at that point, we had all the pieces of the puzzle, I think, and really what the work was to get it ready for trial was to put those in the right order to kind of tell a cohesive story and present it to a jury.
What were the biggest challenges you guys faced, like right away? Like initially, first off, like maybe you didn't know that there was going to be a bigger challenge later, but initially you have this guy, a pallet falls on his head, but I know that there was another temp worker that had been found to be on cocaine, which I think they tried to pin that on at some point. This is just my own layperson's perception of it. But what were some of the earlier, like sort of, okay, we really got to overcome this. What are some of the challenges? Did you even think that it would be a $100 million case early on as well?
So I mean, certainly, anytime you're dealing with someone who's suffers an injury like Mikey did, younger person in their 30s, let alone really anybody who lived a life and isn't going to walk again, isn't going to work again, that you're dealing with something uniquely terrible. And that the possibility of a big verdict is there. Really, the question becomes, is there enough money? Is there enough insurance to compensate them for what they're going to need the rest of their life? So, the initial challenge, I think, was trying to help as best we can someone who's processing one of the most extraordinarily awful changes that could happen to a human being when you walk into work and then by lunchtime you'll never walk again. But then it became investigating and trying to figure out every possible avenue of recovery. Is there anyone else, anywhere, anyway, who did anything else to contribute to this? And so we started to investigate and to dig, and our client, was the initial catalyst too, because he knew every product in that warehouse, encyclopedically. To this day, he still does. And he said, I noticed that particular product, that Philips product, it was packaged differently. It just wasn't secured to the pallets like others were. And so we said, okay, well, let's investigate that. I don't know if that's true, if that's an issue, if they're required to, but let's dig into that and figure out, to what extent the initial packaging of that product somewhere before it got to Connecticut played a role. And it turns out, spoiler alert, it played a huge role.
Yeah, it was remarkable how much our client kind of had it analyzed from day one, and it was us kind of filling in those blanks and a lot of work by Andrew Garza kind of tracking down and following the leads endlessly until we kind of moved up to what we call like first in time, like who had the first ability to prevent something like this from happening.
And Alexa, you were dealing with his wife, right? More because of the consortium
Primarily,
case?
yes. Yep.
Primarily. And so were there some of these things coming from her as well, or was it, or how did that play a part, at least early on, into the bigger case as well?
I think as Andrew Garza mentioned, you're meeting people when they've just gone through one of the most horrific things they may ever experience in their lives. So I think just kind of dealing with all of the emotions that come with that. And then, it literally touched every aspect of their marriage. So kind of just gathering all of that information and then trying to figure out which pieces were the most compelling to bring to trial and who else could support her story.
Yeah, and so it sounds like you're really doing a lot of careful listening to your client, right? And trusting them, especially him, because you're saying that there was this. How did you come to trust him? Because I would imagine sometimes as an attorney, you get clients and you're like, I don't know if this is like, I got to ratify. I got to know if this is really. I mean, I was a journalist for a long time. I get people coming to me for stories, and I'm like, half of what this guy's saying is bullshit, but maybe it's true. I don't know. How do you build that trust with a client? Like, was it the number of years he'd been working there, his employment record, or what was it that made you say, okay, this guy's probably right about this?
Well, I mean, I think part of the biggest thing you can do as a trial lawyer to be effective is to check your ego at the door. We know the inside of a courtroom, we know the rules of evidence, but I don't know anything. I unfortunately know way more than I wish I did about wood pallet standards and the conventions that must be extraordinarily fun, I imagine, the National Wood Pallet Association. But you have to trust that people who do that work know more than you and listen. And to your point about journalism, I mean, you chase the leads, especially in a case like this, you chase all of them. And, it's worth listening to and investigating. And it turned out that was the explanation, and that was what happened. And every step of the way, our client turned out to be right. And as we continued to investigate further back, all the way tracing this product to Hengdi in China, we figured out exactly where the mistake was made. Because in cases like these, we're looking for was this preventable, and if it was preventable, when and by who. And, the simple explanation, I think a lot of lawyers, I'd encourage them to look past the first explanation, because certainly, yes, there was a temp worker in the adjacent aisle that knocks this product down onto our client, responsible as well, no question. But don't stop there, particularly in a case like this where, your client's never going to walk again, and you owe them that full investigation. And at a minimum, you owe them answers. So, that's kind of what we did, is continue to dig into it, talk to experts. In our case, we had one of the best in the world, packaging expert, and he said, yeah, no, that shouldn't go that way. And coincidentally, he said, not only do I know that that's not how it should go out, years ago, I worked for Phillips Lighting at one of their factories in Kansas, and I know they know that. So that became sort of an interesting light bulb moment for us to dig into and sort of see where things led as we pulled the string.
Yeah, and so there's this, I saw that you guys called it a woodpecker approach. What does that mean? Describe what that means.
Mahony, you want it?
Yeah, the woodpecker is just sort of like this relentless bird, right? So the idea is that when you're being the woodpecker, if one door closes on you, you don't stop there. Then you try the back door. And if the back door is closed, then you try the window. And if the window is closed, maybe you try the basement. But you're never stopping for your client. You're pursuing every possible avenue.
And so, but the drive for that was the suspicion that there was a case here. So just to back up too, just to make sure summarizing correctly for folks who don't know anything about this case, you're talking about, and maybe correct me if I'm wrong, a gentleman who works at this warehouse, and a pallet full of material fell from higher up and hit him on the head, basically.
Yeah, if you want, I can. So,
yeah.
I mean, essentially on September 19th, 2017, our client walks into work, and it's a commercial warehouse, not unlike what Home Depot looks like for folks who are shopping. And, he's in aisle 5 and the temp worker is in aisle 6, and there's a bunch of product on the tops of the shelves in both aisles. And unknown to our client, the temp worker is using a reach truck, which is a way of getting things down from the top of aisle 6, his aisle. But he makes contact with the giant cardboard boxes, 1,300-pound cardboard boxes on top of my client's aisle. And he manages to lift and slide one of those off a pallet. It falls down and snaps our client's spine instantly.
Wow. Okay. And so, and the issue there initially when did it come out that temp worker had cocaine in their system?
So that sort of still remains a contested issue on their end. And anytime you have an incident like this, the proper way to do it is to have OSHA come in immediately to report it. Anyone that's involved is sent for, post-accident drug screening, is usually quarantined off. So, you have sort of a clean chain of custody from the moment of the incident until the test. And in this case, the temporary worker tested positive, but cocaine is sort of a tricky thing. It's not like alcohol where if someone has a BAC and you say, look, 0.08 is this and 0.24 is this, and we know what that means in this moment. Cocaine is tested based on, what's left in your urine or your blood. And in this case, they're called metabolites. And so we knew, pretty early that there were significant cocaine metabolites, benzyligonine, in his system, which the logical conclusion is, look, he did a lot of cocaine recently, possibly was acutely intoxicated at the time of the incident. But, ultimately that didn't end up coming in at trial, but it was a factor and something that needed to be investigated, during the case.
How did it end up not being a part of the trial?
So without commenting one way or the other on whether the decision was right or wrong, it's what it was. But, the basic decision by the judge was, this concept of like retrograde extrapolation, right? Somebody's drunk and they have a BAC. We can kind of figure out, well, when did they stop drinking? Did they still drink? And do some math, right? And figure out, where they were at, before, a couple hours before. In this case, can we figure out what was going on at the time of the incident? And really the testimony about cocaine is that you have this acute phase where someone is affected, stimulant, right? Hypervigilant, motor impacts. But then you also, because of the amount that was in the test, you would have had someone coming down from, a recent significant use, which would have had an impact on their motor function. So our position was look, whether he's acutely intoxicated at the time or he's coming down from such an extraordinary recent use, it would have had an impact on his ability to see, hear, observe, and operate the reach truck. The court said, look, all the testimony from everybody is that they saw nothing. There was no empirical evidence. I know you have scientific evidence, Attorney Garza, about the benzyligonine nanograms per mil, but there's not a single person who can say that he was affected. He appeared to have been limited in any way. And so because that could have happened, before that he went to work that day, we just think, given how damning that evidence is and that you're missing some piece of that, we're not going to let a jury hear it. And that's one of those decisions where you get it and you rule and roll. You get it on a Friday and, you grieve for a minute. And I remember that decision came in and we were stunned, but it ended up being a gift in the end, honestly.
How so?
Yeah, so one of our concerns going into the trial is we knew we had a strong case, obviously, against the temp worker and the temp company. But we also wanted to make our case as strong against the Phillips Signify, the primary party that we ended up bringing the trial against. And what we were concerned about settling with these other parties was Signify's ability to kind of point the finger at the empty chair. It's a concern that plaintiffs' attorneys have in any of these cases where you settle out with one party and the other party's left, and they get to kind of point and say, hey, it's that guy, it's that other person. And in a case involving potential drug issues, that becomes an even more dangerous issue. And we knew that the jury would be able to assign some percentage of fault to the temp worker. And obviously we were concerned that if the jury were just heard the words cocaine, like we did when we heard the fact that he was under or had cocaine in his system, that percentage of fault to him would be extraordinarily high, if not potentially dangerous to the case as a whole. So as soon as we knew that it was going to be out of the case, it provided us with that opportunity to talk real significant discussions of settlement with those other parties and just focus on Signify with less of a concern that they would be able to point the finger.
And we knew, because Andrew and I, like, part of the thing that our office does to prepare for any trial is we run focus groups. So we take regular people, off the street, and we present some information to them and get feedback. And that helps us inform our decisions, and it helps us shape our case. And we knew from the focus groups that we had ran in advance of the trial that evidence was very powerful. And so, like Ranks and Garza mentioned, we wanted to sort of shift the focus to Philip Signify. And we knew without that evidence in, we had a better shot at getting a bigger hit on them from our focus group research. So that information was really helpful.
Well, and I should add too that, the drug evidence, really all along Signify's position was, look, this was out of our control. This guy is on drugs. We're not worried about it. But really, certainly we understood what it meant that evidence was not in or wasn't going to come in at trial. But we also knew that going into trial, the jury was going to put an extraordinary amount on Signify too. And the reason was because we found out through our investigation that they had a rule. They were supposed to just attach, if you imagine a giant cardboard box, to a wooden shipping pallet, and that's got to be secured to the wooden pallet. That's a rule. That's their rule. And they broke it that day. And what can happen if you break that rule is that giant box can slip off exactly like it did on this day. And the expert that we had did an investigation, did a reconstruction. We did an animation. And what you could tell from the animation is that essentially this product up on that shelf, because they didn't attach it, it was a ticking time bomb. It could have been the gentleman in the adjacent aisle, could have been somebody else. Really the next person to touch it, if they made any contact at all, it was coming down. So the question did ultimately become, assume he was on cocaine. Would it have made a difference? Did it make a difference? Because had they packaged it correctly from the outset, from the very beginning, we're not here and we couldn't be here. And our experts said, look, if they had followed that rule, that package could not have come down, plain and simple, for a lot of complicated reasons with coefficient of friction and center of gravity. But no matter what, that guy on the reach truck couldn't have knocked it down if Phillips had only done what they said they were supposed to do and followed their own rule. So we knew that the exclusion of that evidence was going to have an impact. And that was okay with us, and it gave us the comfort to settle out with them and provide some security to our client by accepting the policy limits of the other defendants. But certainly we knew that Signify was going to share a percentage of the responsibility too through every one of our focus groups we ran.
And you guys used animations, right, during the case. So how did you overcome having those animations be admissible? And basically, that's a huge question. So, how did you do that, and how did they play a part in the trial?
Do you want me to take this one?
Yeah.
So that was one of my biggest, victories, I think, in that case. I said, look, if I can get in all 5 of our animations, that would be awesome. And we had a couple on damages and a couple on liability. And when we went in for our trial management conference, which is the sort of before the trial meet with the judge and everything, he said, I had people try to put in animations in our last case, and I didn't let him put any in. And I was like, well, we're off to a good start. But, I've taught it, we've lectured on this across the country, and really the answer is a ton of work. And I don't just mean my own. I'm not, it requires a lot of work. So for example, their expert, Phillips's expert, had gone out and did a laser scan, a LiDAR scan of the warehouse itself. You can use drones in these warehouses to take a ton of pictures from every angle. You can use regular cameras to do that as well. And then what you can do is you can overlay all of those photos, images, and measurements and laser, they call them cloud points, and then put the textures on top of it. So we knew, Phillips's expert saved us actually some time and some money because our people were going to go do that. And we said, well, kind of hard to challenge the foundation of an animation if I'm saying I'm taking your expert's measurements. So we took their measurements, their photos, gave them to our animator, and then they put those into an animation that our packaging expert, who also dealt with causation and could talk about the physics of this object, he worked with the animators to make sure that it moved exactly as it was supposed to and consistent with his opinion. So not to get too in the weeds for the non-lawyer listeners, but typically you have two worlds. You have a simulation and you have a demonstrative exhibit. the standard to meet for a simulation, like a shot for shot identical remake of what happened, is extraordinarily high. But demonstratives, yes, should be accurate, and the standard is high, and we want them to not be misleading, right? But they don't have to be so perfect that they have to be a simulation. Though this one, I take pride in. I think it was pretty close to as perfect as you could get it. And so when you have the foundation of the physical environment layered on top of an expert opinion that's been disclosed in the case, and you have the expert work with the animator and say, look, that animation expresses my opinion and illustrates my opinion to a reasonable degree of engineering certainty, then you can at least use it as a demonstrative. So the jury was able to see that, and that was critical in this case, to show the jury what happened and not just tell.
But also, from what I understand, you showed the accident, but then you also showed what would have happened ideally, right?
Yep.
If it was done correctly.
Yeah. Somebody want to take right way, wrong way?
Yeah, and that was kind of critical for us to be able to, and just the animation in general was really important, because we knew, again, through our focus groups, that people were having a tough time, as some people might listening to this have a tough time kind of understanding like the geography and where people were positioned, the fact that the temp worker is in one aisle and he's in another, but somehow he's knocking a pallet in an adjacent aisle. So we knew there was some confusion there, which is why the animation was so important. But we also wanted to show why it mattered, why what we claimed signified wrong and failing to wrap this thing, why ultimately it would have prevented the incident. So we did what we call this right way, wrong way, and we're able to show an animation, again, relying on what our expert could support, of the physics of what would happen if it had been wrapped completely to the bottom of the pallet. And it was a great way for the jury to be able to visualize, like, this would have made a difference. It's not just this wasn't just a technicality that they didn't wrap it to the bottom. They could visualize it and see, and just instead of just hearing it from our expert, the pallet sliding off and then clipping to the top of the racking system, so that it would have completely prevented it from falling off the rack. And so it was just such and we had a great animator that we worked with, and they challenged it every step of the way, like Andrew said. But we tried to use that to our advantage as well. And actually, Andrew took a deposition of the animator for trial purposes to say, like, look how great this guy is. He's a world-class animator and had all this experience. So we tried to take the challenge of them knocking it out and use it to our advantage and make it a strength in our case. So, it was that wrong way, right way animation was also critical to that story.
And we had this theme kind of going that was like $5, 5 minutes, right? So what Phillips did, or what they failed to do in this case, it wasn't hard and it wasn't expensive. And that animation was really emblematic of that, because if they had just done this thing that's inexpensive and easy, our client would still be walking.
Wow. The other thing too is if I'm in a law firm and I can't necessarily afford to make an animation, I don't know how much the animation would cost. You don't have to say, but I mean, some lawyers might look at this and go like, "Oh, well, great, you guys could afford this." What's like a minimum that you could present potentially? I mean, it's kind of a hypothetical, but like, what is like the most effective, or because sometimes I've even seen, like, typically at car crashes, you'll see like a sketch or something from a crash scene investigator, and that can be powerful because it's like they're the expert, they're the investigator. Is there something sort of similar here, of like a minimal viable product in a legal setting, or I don't know, is that too far-fetched of a premise?
It's not far-fetched, but I think it raises sort of an interrelated point, and one that I'm passionate about. So I started a law firm at this point 12 years ago in 2013 as a solo practitioner, and was fortunate to get referred a case pretty early that was way, way, way too big for me to handle, both in terms of experience and cost. And I'm not saying this to scare other folks into referring cases, but one of the things I think you have to keep in mind, I mean, as entertaining and good a movie as a civil action is. Pushing your law practice to the brink of bankruptcy, and to where you're all in on a case is heroic, but it can be reckless. So if you're not in a position to fund cases, to answer your question, I mean, it's tens of thousands of dollars for animations, and they're not right for every case. And certainly, a soft tissue car accident, you wouldn't use one. But in a case like this, where we were running focus groups and we knew that 90 minutes in, people still had, wasn't he right next to him in the same aisle? And so isn't he at fault? And we were like, we're going to get crushed. We're going to get crushed if we don't show folks exactly what happened. And the second that we ran the animation through a focus group the next time, people got it. And the same thing happened at trial. So, I'd encourage people, certainly, push yourself outside of your comfort zone, but recognize sort of if the case is going to get too big in terms of costs, bring someone else in. Or, really there are vendors, to your point, Joe, where, like Total Trial Solutions, or, where you folks will take things on a contingency basis and take a percentage out of the outcome. So if you're confident in your case, like Focus Graphics, my partner, does amazing work. His brother, Seton Claggett, does amazing work with them. They're invested, they're lawyers, and they want plaintiffs' lawyers to be able to have these things for their cases. So that's a way to get animations in your case. But if you can't do that, to answer your question, I think you do the best you can. You have to, we'd have to have more rudimentary drawings. We'd have to explain things on at least a piece of butcher paper and hope for the best. But, when from focus groups that this is a point of confusion and you can clear it up, it doesn't matter how expensive those animations were. They won the case. I mean, the jury saw it. They all sat back, and we understood that they understood.
The other thing I want to ask too is, I mean, there was obviously an OSHA report about this. You have a guy who's seriously injured, and how did that play a part, if at all, in the case? I mean, was that admitted, and what, were there visuals from that were useful or not, or did you guys go deeper than the OSHA report? How did that play a part?
So yeah, I can probably speak on that. So it became I think I was kind of surprised when I joined the case at the lack of depth of the OSHA investigation. They did an investigation, but it seemed to me, at least, that having read a fair amount of OSHA reports, that they kind of went through the motions, did what they needed to do. There were no citations for the employer for any violations, and they didn't do. They took some photographs, but I think it was only, if I remember right, it was like 7 or 8 photographs, maybe a few more than that. And those became obviously integral or important. And we one of the things that we did early on was to get the actual photographs instead of relying on you get a report and you get copies of photographs, and getting the actual photographs that OSHA took ended up being critical, because we were able to clearly see things that ended up mattering at trial. For example, early on in the case, Signify had denied that the product was even theirs, and that was a consequence in part based on the photographs that were in the report. But when you saw the actual original photographs, the native files, you could zoom in much better, and you could actually read like the packing number and the invoice number. And so we were able to kind of knock out certain defenses, and including right at the time of trial, we were able to knock out some of their main arguments as from a defense perspective using those photographs. But the actual findings itself was a kind of a story in the trial. Admissibility of those kinds of things can be a fight in any case. But here, because there were no findings against the employer, the judge, as a way to, without going too deep in the weeds here, the judge essentially warned defense counsel, like, hey, there were no findings here, so don't bring it up. And our point was, well, if they do bring it up, we intend to let the jury know that there were no findings against the employer, because one of Signify's primary defenses at trial was to try to blame our client's employer for what happened here. And so one of the last witnesses of the trial, Signify made the decision to bring up the OSHA report and what some of the things that they found and observed, and we did take the advantage and were allowed to tell the jury, which we thought was fairly helpful. It wasn't. There were a lot of things that I think were important before that, but it was good that the judge kind of kept his word and allowed us to tell the jury that there were no findings against the employer here. It was really undercut part of Signify's defenses here.
So yeah, they weren't given a violation for this incident, and was it they were trying to? You're saying that they were blaming the employer, so like the temp agency.
No, Signify actually just blamed our client's employer itself, who we can't bring a claim against because he had workers' compensation benefits. So
Okay.
That gets very complicated in the weeds legally, and I'm not sure I know the correct answer. Well, the Connecticut Supreme Court will have to tell us someday in a future case how that actually breaks down. But they were trying to blame the client's employer for a number of things, for not noticing that the packaging had been was not to the bottom of the pallet, and basically blaming them for all the things that they did wrong. It was our position, given that really it was what they were trying to argue was control, because the package had left Signify's control, it was in the control of the employer, and therefore they wanted to just say, hey, we don't have any responsibility, it's all on them now. And thankfully I think the jury got it right and rejected that.
Yeah, and to Ranks's point, in our state, I don't know, I think each state has a different version of this, but our state allows, in a workplace incident, someone else to blame the employer, but only to show that they are the only cause, the sole cause of what happened. And here there was compelling evidence that if, Phillips Signify had done what they were supposed to do from the very beginning, this never could have happened. But I think your focus too is on stories, Joe, and I think that's one of the things that really hurt Phillips in this case, because I like to say our story was the truth, because I think it is, and I think our goal, I think you get one credibility chip as a plaintiff's lawyer. You're the one bringing the case, the jury wants to know why they're there, and if your case doesn't make sense to them, if your story is all over the place, I think you lose. Complexity kills your case, and in this case, the defense, all over the place. In closing, I was able to get up and say, look, they're trying this case on three roads at the same time. I mean, their first position they want you to believe is that the employer of our client is entirely responsible for the fact that they missed packaging it right from the beginning. But if you don't believe that, then they want you to blame everybody else, and only everybody else. This guy, the temp, the other people. And if you don't buy that, then, and you are going to blame us, then we're looking for a discount. We don't want to pay everything. We know he's hurt. We're sorry about that, but we don't want to pay it all. So the undercurrent of all of that, obviously, is money. The best result is we pay nothing. The next best result is we don't pay everything. And the third best result is we pay as cheaply as possible if we have to at all. And that's why we're here in the first place. It's classic profits over people. It's not in every case or corporate case, but in this one it was there, and their defense played into it. There's just a narrative inconsistency that's disingenuous about that approach. At least have the courage to say, look, this is what it is. Defense lawyers who will say, look, I'm not contesting his damages, but it's not our fault. There's an honesty to that. But I think that can be the mistake that both sides make, plaintiffs and defense lawyers, that you get too in the weeds on issues and you don't take a step back and say, what do normal people think about that story? They think it sounds like a bunch of excuses. That's what they think. At least that's what our focus groups told us.
So again, that goes back to listening. I mean, you're listening to your plaintiff, you're listening to your focus groups, and getting you're getting into the details of what actually can torpedo your whole case, which is pretty smart. The other thing that stuck out for me in just looking at this case and the story of it is this green band in the trash can moment, which almost feels cinematic to me. Explain that. Like, what is that, and how did that impact the case in terms of credibility and the outcome?
for those of you listening at home, you can't see my colleagues going, "Oh no, here we go. We've been dealing with this for years" on the podcast. But no, that it was a pivotal moment in the case. And as Ranks said earlier, initially Phillips's position was, we're not even sure that thing that crushed that guy, it was our package. And then the next position they had was, well, it kind of looks like ours, but it has these plastic bands on it that are green. And we don't have anything, have never had anything come in or out of that warehouse that shipped it to you guys that's had green bands on it. And, when someone tells you that as the investigating attorney, especially the director of North American logistics for Phillips Lighting North America, you believe him. I mean, how could I possibly know the product better than this guy? I can't. So we sued everybody who touched that product on the belief that maybe there had been a change made between the time it left their warehouse and got to Connecticut. And ultimately that we determined that wasn't true. And then the question became, well, this is a mystery. If they don't have green, how does it get green on it? We know that our client's warehouse didn't repackage it. So you fast forward from 2017 to January of 2021, and my expert drives down from Michigan and I drive from Connecticut to Pennsylvania to their warehouse. This is like still COVID and people are a little squirrely about flights. And the goal is, number one, to inspect the warehouse where this was wrapped, to understand what they have there, who's there. But we're also looking for anything green. Like it's the world's highest stakes game of I Spy. And we walk in the door and Phillips and their employees are just immediately agitated. And not that I would want me on their property if I was them, but we had parameters, we had time, we had what we were supposed to see, we had a game plan, and we adhered to it. And but they were resistant, like, oh, we don't want you to go look at that, even though we agreed to it. And they got kind of cranky, and we just took photos the entire time. And ultimately, there was this one area where they had the wrapping machines that would have packaged this product back in 2017. And they relented and eventually let us go down to look at them. Because I said, look, we can fight this out with the judge later, but we're here and you all agreed we could see these. And we took a bunch of pictures and we saw no green bands that day. And then we got back to the office and I was like, wow, and one of the things that stood out was that the entire upper racks in the warehouse were completely clean, empty. And we're like, this is a busy warehouse. That just seems odd that they don't utilize that storage space. But at the time, the defense lawyer was saying, your client's employer is at fault because they put it up that high in the first place. And I'm like, well, this is a very convenient visual depiction of his defense theory. But in any event, we get home and we start going through the photos, and lo and behold, there was a single green band in a trash can in between those two machines in that area that is the identical color of the one that was on the product that crushed our client back in 2017. And, I'm not encouraging people as a lawyer to commit conspiracies or to destroy evidence, but you got to empty the trash can, I think, if you're gonna. And because when we found that, we said, well, this is a huge problem for them. And surely someone had to have seen it that day, and they're going to say, now we have stuff with that product. But as it turns out, every single witness, we kind of held that very close. Every witness, from their expert, from their number 2, from their number 1, all the way up the chain, said never had green bands in or out of this warehouse, not then, not now, not ever. And then my favorite video of all time was recorded confronting the number 1 at the very end with the green bands and the evidence, and the guy falls all over himself, and it becomes a problem. And then ultimately at trial, it was somewhat limited, how we could use that, but the jury got it. The jury got that. They said there was nothing there. It was there. And there's sort of a second case that's on appeal in federal court dealing with some other issues, including that destruction of evidence and other things. So we'll see how that one shakes out. But, ultimately, I think I don't know what role it played for this jury, but they understood that at a minimum, Phillips's entire story fell apart, that they were trying to cover things up, that this was their product, and, they could have done it right from the beginning and didn't. And that's why they're there.
Yeah, and it became even stranger when we received their experts' photographs who went there like a month or so or 2 months after our team had been there. And we I think literally spent hours with his photographs, or maybe 100 photographs, or maybe even more. And it was, like Andrew said, a game of I Spy, of just looking at the photographs, because what we ended up doing is finding conveniently positioned photographs where there would be a green band way back in the background of a photograph. So they were, from what we were able to determine, they were all over the warehouse when he was there a couple months afterwards. But the photographs were taken in a way as to try to crop them out. And but we were able to, I think, by the end, we had found 17 photographs with evidence of green bands. We were able to come up with kind of in our mind, a diagram of the warehouse and where those actual things were positioned in the warehouse. And it was just amazing how the photographs were taken almost to exclude the evidence of those photographs, but they were just there. They're right in the background, a tiny little spot. Why they weren't immediately, like there was one photograph where it's taken from a direct straight on, and we knew from other photographs that there was literally a rack right above where the photograph cut off that had all pallets with green bands, but the photograph was taken in a position just to crop that right out of the photograph. So it was kind of stunning once we figured it all out.
Yep.
Yeah, and again, we don't know like the exact correlation that evidence had on this jury's decision, but I can tell you that when we were focus grouping that issue in particular, some of the responses we were getting from focus group participants is like, well, we'd ask them like, what's the motive for doing something like that? And it's to avoid responsibility, right? Phillips, at the end of the day, took that action intentionally in an effort to avoid taking responsibility for the harm that they caused a paralyzed man. So our focus group participants were pretty angry about it, but again, we don't totally know how the jury felt about it. We can only assume.
Yeah, and the other issue that I mean, as an investigative journalist, used to run into this all the time, is that you have a subject, or in this case a defendant, that keeps on sort of giving all these inconsistencies that you're aware of. At what point do you let on that you know, or how long do you wait for them to keep going with this so that you can accrue more evidence, like to decide when to confront them versus just letting them keep going with these inconsistencies?
So that was a question we struggled with, because when we found it in the trash can, there was still a lot of discovery and depositions left to go, and we wanted to say, aha, we gotcha, but ultimately we looked at it and we said, look, well, we want to know what they're going to say about this, and I'm not going to tell them we found it, but I want to just confirm that, because if I'm them, I'm going to say, oh, yep, that there actually are green banded packages going out of that warehouse now in 2021, but there were not back in 2017. Awfully convenient that the color is there now, but wasn't there before, but at least plausible for why that's in a trash can on that day. So I want to know what they're going to say first and what that's going to look like. And so ultimately, we decided to take our depositions in a very specific order, starting first with their expert. And he said, look, I didn't see anyone. I was there that day. Of course, we know they're in the background of every 17 different photos. And he interviewed the people, the number 2 and the number 1, and they told him, not now, not then, not ever. And I said, not now either, right? Not ever. And he said, no. And I said, okay, well, that's bad for them, but let's talk to the number 2. Maybe she's going to say now, right? Because she's there every day, and that guy was only there one day in March. She gets on, she says, not now, not then, not ever. And I said, well, we may have ourselves a bona fide corporate conspiracy. Surely the number 1, who's been there the longest and is there every day and has been there twice as long as the number 2, is going to say, yeah, now, because there's nobody, in his words, there is nobody in the world who knows that warehouse better for him, under oath. The buck stops with him. And he said, not then, not now, not ever. I couldn't pick that color green out of a crayon box. So I said, okay, well, we'd made a decision that if once we got that testimony, we were going to lock it in and then we were going to confront. And I said, okay, well, before we're done here, is there anything you want to change before we move on? And he said, no. And I said, you've been truthful and, you understood my questions. And I said, okay, well, I got one question. I shared the photo. Can you tell the jury why there was a green band in the trash can that day we won? And he didn't love that question, and began to sort of, after a very, very long pause, sputter, and it just got worse from there. And then we confronted him with their experts' photos, and At that point we said, well, surely their lawyer, they're going to report this and say, look, our clients have been hiding and our guy's paralyzed and they'll come to their senses. And even then, after being caught and confronted, they didn't. And tactically, if people are wondering why we did it, it's because, look, maybe there's some answer at trial that they're going to come up with or come out with that if we don't confront them on video, because we record every deposition, if it's worth taking, it's worth recording. And you want to know, especially with the guy in the wheelchair, you want that certainty. I want to know what they're going to say about it. But yeah, pick your spots, structure strategically how you do it. Make sure you lock in anybody who's going to give you an excuse when you have a lie like that. And then I'd encourage you to confront them. Because look, if they tender the policy limit, this was a contested liability case. The jury could have come back with 0. I got a guy who's never going to walk again, who has medical needs for the rest of his life. It's not about ego, right? So if I can confront him and the case gets resolved for limits and they're not put through the trial process and he's taken care of, great. If not, then we're going to do our jobs, as we did throughout the entire case. And they decided they wanted to continue to dig in and put all their chips on the temp blame and the employer blame, and that 100 million reasons why that didn't go well for them.
And they still denied it at the time of it. Right at the end of the trial, we gave them a final opportunity. Like, if you don't want to fight about this, you can just admit. And they would never admit that this product had green bands at the time it was in their warehouse.
Yeah, the other issue here is that kind of shifting to one of the big challenges I saw here is that there were some suicide attempts. And that there was a concern about how that would play. Can you describe that and how you overcame that?
Yeah, I think that kind of comes back to focus grouping and how important that is to understanding which pieces of your story to tell and how to tell it. Because for the non-lawyers out there, when you go to law school, they basically scramble your brain and you stop thinking like a regular person. And so we think we have an idea of what evidence is going to look like to our jurors. But the reality is a lot of times we just don't know. There's a disconnect between how we're thinking about the case and how they're going to perceive it. So when we first found out about the suicide evidence, our crazy lawyer brains were like, this is terrible for us. We cannot get this in front of a jury.
And I just want to be clear, it's the plaintiff had attempted suicide?
Correct.
Okay.
Yeah.
A few times?
A couple of times. Pretty close in time to the incident. I think from a human perspective, it's totally understandable, but we had major concerns about it because, we were going to ask the jury for a lot of money. And one of the justifications for that money is, he needs care for the rest of his life. He's going to be in pain for the rest of his life. And so as morbid as it is, our thought process was kind of like, if the jury finds out he's going to kill himself, they may give him less money because he's not going to live, and then he doesn't need all of these things we're saying he needs. But the reality is when we presented that evidence to the focus group, the feedback was overwhelmingly in our favor, that they just saw that as another harm that the defendants had inflicted on him. They saw that as, a relatable thing. A lot of people, some of the feedback we were getting was like, I may feel that way if something like that happened to me. And they were so much more receptive to that idea than we thought. And they didn't want to blame him for it at all. And then the fact that he had overcome, those suicidal ideations with the help of his wife and sort of like the support of his family, and found a way to be hopeful after all of that was a really compelling story. So I think a hard lesson that we learned was we're not always right, and that's why it's important to test the evidence and how you're going to tell the story, because if we didn't have the advice of our focus groups, we probably would have left or tried to leave it out, and it ended up being a very compelling piece of our case.
Yeah, and to be clear, the suicide attempts were after the incident? Accident?
Yes.
Okay.
Yeah.
And then I want to make sure, just, Andrew, do you have to get going soon? I can't remember when you
Nope,
have to leave.
I managed to get another 15 minutes, so we're good.
Okay, because I wanted, that'll change.
Appreciate it.
Because I want to make sure that we're respectful of your time.
Thank you.
Okay, so we don't have too much more to go here, but I want to slide in a few more questions. You guys are doing great here, but do you think like the verdict you guys talked about this a little bit, but was there any one thing that you feel like it hinged on, like the liability proof, the damage, or the credibility damage to the defense? Or was it kind of a mix, or what did you think was kind of the most impactful of those things, or was there another thing that you feel like may have been a bigger factor?
Yeah, I think it's a little bit like trying to deconstruct a dinner after it's cooked, right? But honestly, to this day, and I'll always believe, the biggest single factor was our clients. They are and remain two of the most incredible people we have ever met and had the privilege to represent. We just built out our new space in December here, with a full courtroom, and above it there's a giant brass plaque that says the house that Mikey and Emily built, and we mean that. And they were who they were. To Alexa's point, their authenticity is important in being able to tell a story and tell a hard story, like a suicide attempt. But also, it's when you dig into that stuff that you even get beyond that and you realize there's power behind that. So, our client had a brother who was struggling and had come back from overseas in the military, and then it ends up not only being a story about how our client has struggled, but we find out our client, and through his own struggles, has helped his brother who was dealing with similar issues. And so, there's really, our client's hospital bound after this, and Hurricane Maria hits Puerto Rico, where his family's from and he's from and was born. And he's in a hospital bed, and he's just been told, you have a 3% chance you're ever going to walk again. And meanwhile, he's trying to coordinate care packages to his family from that situation. That's just who this person is, and that's not something you create. That's just who people are fundamentally to their core. And I think the jury saw them and their marriage and who they were and what he was to his family, and he was their back. And he, walked to and from work and to school and with his kids every day. And I think that verdict is a reflection of who they are as people. Certainly, what was done to them was unforgivable. It was avoidable. It was preventable. But I don't think that verdict is the largest in Connecticut history without the Cruzes being the Cruzes.
Yeah, so, and that it gets to maybe just a really nuts and bolts question. If I'm listening to this as a layperson as well, it's $100 million, which is the largest bodily injury verdict in Connecticut history, from what I understand. Why is it so much money? How did it end up being such a huge verdict, and what does that really cover?
I certainly there are the tangible things that you can count, right? The dollars and cents, the economic losses of a life of future medical care, a life where someone is younger in their 30s and is going to need that for longer than someone who won't if they're paralyzed later. But the largest part of that case too is, as best as money can do it, our jury instructions say your job is to put them back in the position as if this would never have happened. And, we had focus groups where, there's nobody in the world. Sometimes you see billboards where people are smiling with a check and 7 figures on the billboard. And I can tell you with honesty that there's not a single client I've ever represented who's gotten a settlement or a verdict like that who you would want to trade places with for that amount of money. And so that's one of the things. The jury's not, I don't want to say they're putting themselves in the shoes, but they're trying to figure out what that is worth. The loss of connection with your grandchildren, who are afraid of you because you're in a wheelchair. The loss of the ability to do everything that you were passionate about, to be connected to your wife in the way that anyone wants to be to their spouse. The ability to have the self-confidence to provide for your family as you always have and be the person they lean on instead of the person leading, right? And so, we gave them some ways to think about that and, how to value that loss. And, from talking to some of the jurors, actually, apparently they initially had considered $150 million. So I think Phillips got a bargain that it ultimately wanted. So
yeah, and I think to Andrew's point, one of the it's why we're in the line of work we are, because we believe in the jury system. And I think what we're seeing with both in Connecticut and with our sister firm in Vegas, they're trying cases also all over the country. We're seeing is that jurors, like this is in a world that's increasingly getting bigger and more complex, and there's all these issues with institutions and a lot of public, questioning the system. But the one of the remaining bastions of our system is the jury, and I think jurors are recognizing that the power they have to kind of be a part of the system and make decisions. And what we always preach and advocate is full justice for our clients. It's why Alexa, as she did with the loss of consortium claim in this case, got a verdict of $10 million for Emily's loss. Like jurors are recognizing that the entire picture, and awarding full justice under the law that they can to compensate people for these harms, not only in this case, but we're seeing it all over the country.
Yeah, and Alexa, that is, like, from what I understand, the largest loss of consortium verdict in the state history of Connecticut as well, which is huge, which is part of this $100 million total, from what I understand. Yeah. So what was that for? Like, I mean, most people, lay people, hear that and be like, geez, $10 million, why? What was that for? Could you explain a little more about how it resulted in such a large verdict for that part of the case?
Sure. I mean, I think it's a similar calculus to, the things that they were considering for Mikey. I mean, obviously for her, there's no medical treatment, right, and things like that. But I mean, some of the things that the jury heard was she basically sacrificed the life that she had before this incident to become her husband's round-the-clock caretaker. And I'm married. If there's listeners on this call who are married, you take those vows, like, for better or for worse, and in sickness and in health. And I mean, she was really living that. I mean, to be someone's full-time caretaker and deal with, helping them toilet and bathe and dress themselves, and pulling him out of this dark depression that he was in after the incident, and just literally never leaving his side and kind of just being his rock. But at the same time, also hearing about the impact that and the toll that took on her to continue to be that person for him. And the impact that kind of had on their family dynamics and everything else. Like I said, it touched every aspect of their lives and their marriage, and that's what the money was for.
And then just to break it down kind of nuts and bolts, you have a $100 million total verdict, the $10 million loss of consortium. From what I understand, the economic damages were $15 million, and then the rest, the difference there is the non-economic damages, which is like $75 million. Is that correct?
Mm-hmm.
Mm-hmm. Okay. Good, because I was just kind of doing the math there and the whole way. But for like lawyers who may be watching this who handle catastrophic injury cases, like, what did you learn from this case? It's a two-pronged question, kind of big questions. And then what's one mistake you see repeatedly that often leaves millions on the table that maybe you guys have made before yourselves that you learn not to make?
Maybe if someone else wants to talk about data or focus groups, but to me, what still stands out about this case is, we admire and still do really famous trial lawyers, my partner, Sean Claggett and Nick Rowley. And, when you see the results they get, you think, I can't do that. And so there's sort of a self-doubt component to trial work where you kind of convince yourself that you can't attain that. And to me, one of the most remarkable things about this case and the verdict is how unremarkable the trial process was. I think there's an inclination that there must be some explosive fireworks moment. And we had some sparks during the trial for sure, but the case went in every day. We all did our best work. We took care of one another. We went home, we got rest, we got up, we did the best we could do. We wrote strong, solid briefs, and we made good arguments, and we followed our data and our focus groups. And when the verdict came back, we were overwhelmed. I mean, it's a day that none of us will ever forget for as long as we live. And when I think back on it, it's like that's the largest verdict in Connecticut history. And again, I think because of our clients, but if you do the work and you have a good team like we do, and like the folks that are here, those kinds of results are possible. So don't doubt yourself, and don't believe there's some magic other than, I think, hard work and having the courage and the team to do it. And
Andrew, you said something, I think, on like LinkedIn about bouncing back. to this verdict and having like a pretty substantial setback before it. Can you explain a little bit about what that?
Yeah, so the last case I tried before this one was functionally a rear end motor vehicle collision, a little tiny bit more complicated. That's how I make myself feel better. But I lost, and it was a case that I thought I should have won. And there's some kind of a statistic somewhere that says if, plaintiff's lawyer loses 3 cases in a row or something, and they may just stop practicing entirely. And I wasn't there, but I was at a place where I was doubting whether I was even any good at this work and whether it was right for me. And some part of it is just you have to use them as opportunities to get better. And one of the biggest things that came out of that case for me, when I really stepped back, if I was honest with myself, which it can be hard to do, is when I explained it to people, they were confused, just like our focus groups were in Cruz, about who was in what aisle and who was where and who was it. And I said, okay, well, never again will I leave the sort of mechanism of event, like what happened. If it's confusing and needs to be explained, it will be explained and it will be visual, because complexity means you lose. And so that was a lesson that we carried forward and sort of took those hard-earned lessons with us forward into the Cruz case. And there's also a saying that the sort of most dangerous person is a plaintiff's lawyer coming off a defense verdict. And I think for every reason we've talked about, we love these clients and we're motivated to do well, but also, we learned a lot of lessons, and you have to be willing to learn lessons. Win or lose, we deconstruct the trial. We get together, we talk about what was good, what was bad, what could be better, because there's a human aspect to this work too, where we are families. It's not just us, Alexa and Ranks and I, that are on trial. All of our spouses and children are on trial with us. Like, that is a massive demand on your family, your people, your community, your work environment. So what can we do every time to make this better and get ahead of it and try good cases? And one of the things is absolutely learning from losses.
Yeah, I think that's a point that we all embrace, is like no trial is perfect. And in situations where you do have setbacks, whether it's just losing a motion or losing a trial, you can do one of two things. You can make excuses, you can blame the judge, you can blame your client, you can look inward and see how can I improve. And to your other question, one of the things that we've mentioned a few times here is focus groups, and also we're now using a lot of data, big data, which is a way to kind of do focus groups at a larger scale and be able to again, not just trust our instincts, but verify what we can empirically, with either through just meeting with focus groups or with data, to try to know the answers to the questions that we all have going into a trial, like how is evidence going to be perceived, how is this issue going to be addressed. So I think one of the things that we are pushers of to the plaintiff's bar as a whole, and we've tried to give training and CLEs on this as well, is just to use the available tools like focus groups and data in order to help yourself and help your clients.
Great. And I think we're kind of running out of time. So I want to thank you guys for doing this. You did a great job. There's a lot to learn. I think there's even more potentially to get into, but we kind of have to leave it there. Anything else that you want to add before we wrap up?
Mahony, anything?
I don't think so. I mean, we could probably talk about this case for days.
Yes.
So thank you, Joe, for listening to us, and hopefully the listeners enjoy it too.
Try your best cases if you're a plaintiff's lawyer. Stop settling your best cases. That's the only advice I can give you.
Well, that's it for this episode of Make Your Case. Big thanks to Andrew Garza, Alexa Mahony, and Andrew Ranks for joining me and sharing their insights. And thank you for listening and watching. And if you enjoyed this conversation, be sure to subscribe so you won't miss future episodes. I'm Joe Douglas, founder of Clear Eyed Media, where we help attorneys present cases more effectively with professional video storytelling for mediation, settlement, or trial. If you're a lawyer with a case you'd like to talk about on the show, send me an email at joe@cleareyedmedia.com. I'd love to hear from you.